From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Senate Democrats prepare to take up their Supreme Court reform bill as the parade of ethics complaints continues in the press. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, editorial board member Colin Levy and columnist Alicia Finley. Welcome to you both. This week, the Senate Judiciary Committee is planning to mark up and vote on the Supreme Court reform bill offered by Senator Sheldon Whitehouse of Rhode Island. It is called the Supreme Court Ethics, Recusal, and Transparency Act. Here is a piece of a statement by Whitehouse and the Judiciary Committee's chairman, Dick Durbin. The belief that justices should not be held accountable or even disclose lavish gifts from wealthy benefactors is an affront to the nation they were chosen to serve. To hold these 9 justices to the same standard as every other federal judge is not a radical or partisan notion, unquote. And here's a clip of Sheldon Whitehouse expanding on that argument on the floor last week.
This bill would put basic ethics guardrails and transparency measures in place to help ensure the American people that they can get a fair shot at the Supreme Court, even if they don't have a private jet. Today, in the court that dark money built, the honors system has flagrantly failed. We need to legislate, we need to investigate, and we need to fix this mess for the American people.
Colin, you've looked at this legislation. Can you give us a sense of what it does?
This bill, Kyle, basically would require the court to create a code of conduct within 180 days. It would also require disclosure rules for any sorts of gifts and income, travel, things like that. And it would then refer any ethics complaints to a 5-member panel of judges from the circuit courts. Everyone seems to think that it would be somehow a good idea to have circuit court judges sitting in judgment of Supreme Court ethics. It's obviously a bit of an awkward situation, especially considering that Supreme Court justices are routinely reviewing the decisions of the lower courts. So, that's sort of adding an extra layer of politics there. And, the bill would also lay out circumstances requiring disqualification to hear a case. That's, what we generally call recusal. As it stands now, justices make their own decisions about when they can't be impartial when they're listening to arguments. And those rules have, by all accounts, governed the court quite reasonably for a long time. I think as I know we'll discuss more today, all of the complaints and allegations against the justices that have come out as the Democrats have tried to delegitimize the conservative justices on the court, not one of them has in any way suggested that any of the trips or any of these other things that are alleged against the justices affected their decisions or was, important to a matter before the court.
Democrats are pitching this bill as a way to restore confidence in the Supreme Court. But to my eye, there are a couple pieces of this that would do the opposite. The point that Colin was making about this ethics complaint process, the standard in the law is that you could file a complaint that a justice has engaged in conduct that undermines the integrity of the Supreme Court, which is very open-ended and seems to me like an invitation to political complaints from the left or from the right against this justice or that justice that they don't like. And on the point about recusal, parties in a case would be able to make a motion that a certain justice recuse, and then that motion would have to be heard. But Alicia, I think you'd get in the same sort of situation. I mean, think about the Harvard affirmative action case that was just decided on racial preferences. You might have a motion from one party saying Elena Kagan was a dean at Harvard Law School, and so shouldn't she have to recuse from this? You might have a motion saying Clarence Thomas was a beneficiary of affirmative action and has wrote in his memoir in no uncertain terms how he feels about that policy. And I don't think those recusal ideas have merit under the recusal standard as the Supreme Court generally follows it. But if you're a party in one of these cases, Alicia, it seems to me you'd have a huge PR interest, at least, in going down that road.
There's really no limiting principle, as we like to say in court decisions. There's no limiting principle to the kinds of motions that parties could file for recusal. I mean, if they want to get the desired outcome. You could see this becoming essentially weaponized. For instance, as you point out with the Harvard case, they could find, well, they could even go further and say, well, these justices all attended Ivy League schools, and so therefore they are somehow conflicted because all Ivy League schools will therefore are and somehow implicated by the Harvard case and the affirmative action. Again, no limiting principle. And we've actually seen this happen. The agencies, the NLRB, several years ago, and this was during the Trump administration, there was a case involving the joint employer standard. And there were arguments that one of the board members should have to recuse because he worked at a law firm that had a client involved in a case that board was hearing and was considering to overturn. Now, this was, again, a very strained argument and strained recusal standard, but the progressives in the Senate and activist groups tried to make a lot of hay out of it and really actually ended up intimidating the Republican commissioners and forced one of them to recuse himself, even though he had there was no legitimate justification for him doing so. So I think a lot of this is really just about intimidation and right now trying to bully the court by using the guise of ethics.
Colin, the other thing that strikes me here is to repeat a piece of that statement from Durbin and Whitehouse. They say to hold these 9 justices to the same standard as every other federal judge is not a radical or partisan notion. And I guess my response to that is the 9 justices are not like every other federal judge. And in one big way, it's that if you're on a circuit court or if you're on a district court, there are all sorts of colleagues that can come in and replace you if you have to recuse from a case for one reason or another. And that's not true at the Supreme Court. There are only 9 of these people with life tenure. And so if one of them is pushed to recuse in a situation where they don't really feel like they have a conflict of interest, you can end up with decisions that are split 4-4, no clarification in what the law is supposed to be across the country. And then I think something that's also missed in some of the coverage of this is when they're talking about parties that are asking the Supreme Court to take a case, it requires 4 yes votes to take a case. And so a recusal in that situation is equivalent to a no vote. And so it makes it more difficult for some of these cases even to get to the Supreme Court, whether they're meritorious or not.
No, I think that's absolutely right, Kyle. I think it would be a mess. I think what we have to remember as we look at this is that the only thing that's really going on here as we're listening to Mr. Durbin, Mr. Whitehouse, is this bill would give Congress control over the Supreme Court. That's all that this is really about. And that's a direct conflict with the separation of powers. As you were just referencing, Article 3 of the Constitution says that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. By the way, the Supreme Court is not the same as the lower courts. So to use this kind of nonsense line that, well, we're just going to extend to the Supreme Court the same powers and rules that we exercise over the lower courts, it's nothing more than just a political ruse here.
Alicia, do you agree with that assessment that there is a constitutional problem with the kind of proposals that Sheldon Whitehouse is putting forth? I mean, the argument that Democrats are making is the Constitution, yes, says that there shall be a Supreme Court, but, for example, does not say how many members it will have, and that has varied over history. And so Sheldon Whitehouse and company are saying, we're not dictating any of the merits of the court's decisions. We're not trespassing the separation of powers. We're just putting some procedural things in place, like the Supreme Court has 9 members instead of 7 members. They're analogizing this kind of ethics reform to that kind of basic groundwork. Or do you agree with Colin here that, when you're talking about knocking justices out of cases by recusal standards and so forth, that gets into the merits of what the Supreme Court does in a way that does create a constitutional problem?
The motivation of this, we have to recall, is really just to intimidate the Supreme Court. And maybe if there were a legal case, if this legislation were to pass, I'm not sure that would necessarily be an argument, a legal argument for overturning it. But I think there are definite separation of powers issues at play here. I think that there's no doubt that there would be a legal challenge. I take your point in that, yes, the Congress has some control over the Supreme Court. It can add, pack the court as it has been threatening to do. But I also think that there are legitimate questions about the separation of powers and to what extent the Congress is now infringing and interfering with the court's business.